You're
All right,
muted.
welcome everybody. Welcome to another episode of Coffee with Chris, where we try to provide you with as much free information as possible, both on the legal side and on the healthcare advocacy side as well. And today, it's my pleasure to have on Matthew Bravette. He's going to talk to us a little bit today about special needs trust and special needs planning. When to consider these aspects of planning, who should consider these aspects of planning. Matt has particularly interesting background in special needs. So welcome, Matt.
Hey, yep, thanks for having me.
Yeah, absolutely. My pleasure. If anyone has any questions as we're moving along, please feel free to jump in and ask us any questions. We're more than happy to answer those. If you need to get in touch with us toward the end, we'll let you know how to get in touch with us, and then you can ask us any questions that you may have. So we'll start off, Matt, if you can, give us a brief background for yourself and why you're particularly interested in special needs planning.
Sure. So as you said, I've got a bit of a unique background here and interest in special needs planning. I actually have an identical twin brother named Christopher. He's got severe cerebral palsy, so things were always a little bit different for our family. As I spent a lot of time in and around the special needs community, I realized I wanted to direct my focus and then eventually legal practice to helping families similar to my own.
Right. So it definitely hits close to home.
Yep.
So why, to the audience, why should anyone and under what circumstance consider special needs planning?
Sure. So there's a lot of reasons to consider special needs planning. There's a degree of personal protection, I think, afforded by setting up a procedure for someone to be able to come in and assist you if you have some kind of a medical, social, or maybe a financial crisis. The form that takes is going to depend on each client and the devices that are available to us to accomplish that client's goals. Specifically within the special needs realm, if you Google something like special needs planning, you'll see any number of blog posts touting the absolute dire critical necessity of having some kind of a plan in place if you have a disabled loved one. I think it's important to target certain groups as having, targeting certain groups that maybe are seen as having a higher need. But I think that estate planning is absolutely critically necessary for everyone, regardless of whatever the ailment or situation may be. Having a physical or developmental disability doesn't necessarily move the needle, in my opinion. It just changes the tools and methods that we have available to us to help. But as a lawyer, we thrive in exceptions. So I would say that my exception to that is special needs planning is particularly critical when we're looking at gaining access to public benefits or preserving assets for the use or benefit of a disabled person and then their family, because it can quite literally be a difference of quality of life and death in some of our more dramatic cases.
Right. So, and who considers special needs planning? I mean, at what point, at what stage does a family consider special needs planning? And I'm sure there's, a wide spectrum of disabilities, right? So who should be considering, at what stage should they be considering these types of planning techniques?
So special needs planning is, I think, more relevant to a wider range of people than the name alone implies. So when we look at who's considering special needs planning, it's a pretty diverse group of people. At what point we're considering special needs planning is going to depend on the circumstances of each case. For example, one of the special needs planning tool sets that we have available would be a guardianship. Now, a guardianship is something that you would only need after a person turns 18. So in that context, you maybe have a family who has a loved one who is unable to make their own rational or informed choices regarding their health, their finances, their safety. But something like a guardianship might not be necessary until they're 18 or right on the cusp of adulthood. The reason being, when a person turns 18, in the US, there's a presumption of competence by default. Our legal system, thankfully for some of us, doesn't try to predetermine who on the edge of turning 18 has the ability to make those rational informed choices. So in that case, it's up to a parent or a loved one to bring the lack of decision-making ability to the court's attention to go through the necessary mechanisms to have something like a guardianship put into place.
And even within the guardianship realm itself, there can be a range, right? Because you don't have to be completely incapacitated. It doesn't have to be a full guardianship if a parent is seeking something. There can be limited aspects of the guardianship where maybe the child only needs help in certain areas and they're allowed to make other decisions, their own decisions in other areas. Is that correct?
Absolutely, yeah. So guardianship can be very flexible in terms of what the intended guardian can accomplish. Not everybody is going to need the full range of protections that are afforded under something like a guardianship. We might have a client who really only needs help making healthcare decisions, or we might have a client who is able to understand and make rational, informed healthcare choices, but maybe they're not so good with quantities, numbers. So maybe they're not able to adequately manage their own finances. So something like that, a guardianship could be more narrowly tailored to help the protected person without kind of overstepping the bounds of stripping away independence where they could otherwise be independent. And so, for that reason, it's important to make a realistic assessment of what the client can and can't do, or maybe what they need additional assistance with. And there's a number of different ways to do that within the context of guardianship planning.
And then once that guardian has the guardianship in place, depending on what the judge's order says, it could be limited only to certain aspects, as you alluded to, or it could be general. But then they would have the ability, if it's general, they would have the ability to make medical decisions, financial decisions, in all aspects. Correct?
Yeah, and so it's more than just kind of the broad sweeping overview would be healthcare and financial decisions, but the day-to-day decisions are things that really come into play with a guardianship. Things like enrollment in beneficial programs, things like enrollment or placement into an adult day program, or different, providing consent for different therapies, different treatments, making the day-to-day financial transactions. It's not just directing, okay, this is where we're going to put all this money, and this is how we're going to allocate it. It's paying for everyday things. It also entails a degree of protection, like I mentioned. I mean, a lot of times when you're looking at somebody who is a candidate for a guardianship, they're also a candidate for financial or other types of exploitation or abuse. And so having that guardianship put into place can limit or help to protect against occurrences of financial or other types of exploitation or abuse.
So when we're talking about finances and we're talking about governmental benefits, special needs trusts, there's different types depending on whose money is going into the trust and who's managing the trust, who's going to be the trustee. So can you tell the audience, the different types of trusts and maybe give some examples of when you would use each?
Sure. So the special needs trust, as a broad overview, it's a special type of trust established under the Social Security Act, and it's designed to hold assets for the benefit of a disabled person without causing their financial disqualification for means-based benefits, such as Medicaid or supplemental security income. When I say means-based, I mean benefit programs that you're not entitled to simply by virtue of having some kind of a disability or other type of qualification. Instead, you have to meet maybe a financial eligibility component or an income eligibility component. And so what we have to do is we have to move the disabled person's assets into a different type of device in order to allow them to still get those very valuable benefit programs or participate in those programs without having them spend down or impoverish themselves first. You had mentioned that there's a couple different types of special needs trust, and that's certainly correct. I mean, there's kind of the most commonly used ones we would see would be a first party or third party special needs trust. And you'll hear those referred to or see them referred to sometimes as a D4A based on the code provision that they fall under. But the primary distinction between them, you're looking at whose assets are being used to fund the trust. So the first party trust, you're looking at an irrevocable trust funded by the disabled person, their parent, maybe a grandparent, a guardian, or by the court. But they're using the disabled person or beneficiary's own assets. And so we would typically see those used in a couple scenarios. Maybe if there's a birth injury or an injury at an early age that results in a serious disability or some type of impairment to the child, oftentimes you'll see a lawsuit and there's some kind of large monetary compensation. And in that case, we would want to potentially transfer assets to special needs trust in order to protect them for that person's benefit later in life or even in the earlier age, and cover expenses that wouldn't otherwise be covered by their public benefits. It's not only for children and people injured at birth. I mean, sometimes we have an injury later on in life. Maybe there's an accident, workplace, car accident, whatever it may be, leave somebody disabled and they cannot continue to work. And in that case, you might, again, transfer assets that you've accumulated over the course of your life working as an adult, transfer them into a special needs trust if you check all of the necessary boxes. Transfer your funds into that type of a trust in order to qualify for benefits without being subjected to some of the transfer penalties that you might receive otherwise. The third scenario that I would say, and maybe a little bit less common, but sometimes where we have somebody who's already on Medicaid or social supplemental security income, if they're about to receive an inheritance, or maybe a parent passes away, leaves them some money in the will, and receipt of that inheritance would cause them to lose those benefits that they need, we could potentially put those assets into a special needs trust to prevent them from losing that benefit. There's a couple other considerations. I mean, you have to be under the age of 65. And it's important to note that special needs trust, well, first party special needs trust, is going to have something called an estate recovery or Medicaid payback provision. Basically, what that means, when somebody's receiving Medicaid benefits, the state keeps a running tab. And eventually, when that person passes away, the state will try to recover from their estate, subject to certain limitations. But the first party special needs trust would generally have a requirement in there that upon the beneficiary's death, the state would be able to recover from that trust. The other type you had mentioned, the third party, the distinction there is that it's going to be funded with somebody else's assets for the benefit of a disabled individual. And so the intended beneficiary, the disabled person, their assets are never going to be put into a third party trust. And so, in other words, if I put money into the trust for my brother, it's going to be a third party special needs trust. If my brother puts his own money into a trust, it's going to be first party, and it's going to be subject to those stricter requirements that I had just mentioned. Third party special needs trust can be particularly useful because there's a bit of a misconception that we see in the estate planning realm when people, sometimes they seek to disinherit a disabled loved one because they know that they're receiving some kind of means-based benefit and they don't want them to lose that eligibility. More commonly, we'll see parents who want to leave a disabled child share of their estate to a non-disabled sibling with the intent that that money is going to be used to provide for the disabled child's health and well-being. The idea behind it's positive, but it can be problematic and sometimes a potentially devastating mistake. The way around that is we can use a third-party special needs trust so that child can still receive their inheritance from their parent. It can be used for their benefit and to help provide for their care, supplement things that aren't covered by their existing benefits without causing that disqualification. It's worth pointing out that we can create a special needs trust through a properly drafted will And so it's not something that necessarily has to be funded in life. It can be funded with life insurance benefit, for example, that payout. So there's a couple different ways to do that. The other primary benefit, I would say, to a third-party special needs trust, it's not subject to estate recovery or Medicaid payback. And so in other words, generally, when you're receiving benefits over the course of your life, you're going to accrue a pretty large bill. And when you pass away, a lot of times we see trusts almost completely depleted, if not completely depleted. The third party is not subject to that requirement. And so the assets, any assets remaining in that trust account at the time the beneficiary passes away, could be distributed to other beneficiaries. And so sometimes we'll see parents name other non-disabled siblings as the beneficiaries of that trust.
Yeah, and that's, those are good points that we could probably have an entirely different discussion about. I mean, there's as you pointed out, there's the testamentary SNTs, the special needs trust. There's inter vivos, which you're creating prior. So while you're alive, you're creating a trust. It's called an inter vivos trust. So, a main difference there is if it's testamentary, the testator is the one that's contributing the money in the third-party special needs trust, versus if we set up an inter vivos trust, a standalone trust, anyone can then contribute. So that the testator can contribute via the will, aunts and uncles, cousins, nephews, friends, anyone can contribute to that third-party special needs trust. It's not just the money coming from the decedent themselves. So there's a lot that goes into the estate planning. Also, in a blended family context, again, you don't necessarily want to, if one spouse has children from a prior marriage and then remarries, you don't necessarily want to leave everything to that new spouse, because then your kids can be disinherited. So, there are different ways to leave it. There are different assets that you may want to leave. So you may want to leave a life insurance policy to the special needs trust versus, an IRA or something, if you're going to leave your spouse an IRA to get that stretch out opportunity that has changed a bit in recent times. So it's very complex. Can you talk about a special needs trust versus an ABLE account, and when you may consider using each of those?
Sure. And just on the subject of the special needs trust, there is a third one that I wanted to mention briefly. So there's a pooled special needs trust, which is a little bit different than your first and third party. And this might be a good option for somebody who has they want to fund their own trust on their own behalf. Either they don't have third party intervention or they can't rely on it. And maybe they don't have as much money as you would typically see with a first party special needs trust. And so the pooled trust could be a good option. It's managed by a nonprofit and generally requires a much lower cost to set up. And it's just it's something to be aware of as far as the special needs trust realm goes. But the ABLE account is pretty cool, actually. It's a relatively new type of account, and I think they've been around since 2014. You're eligible to participate in them if you have certain qualifying factors. And so only certain people can open up an ABLE account. Typically, you would have to be below, or your disability would have to have manifested itself prior to the age of 26, and you're eligible for or receiving SSI or SSDI. And there are other types of qualifying factors. There's compassion allowance conditions and some other ways to qualify, but I think they're beyond the scope of this conversation. But notably, the ABLE account serves a similar function to the special needs trust in that it's another way for you to store assets or to preserve assets up on the side and still qualify for certain types of means-based benefit programs. There's a bit of an important distinction, though. So if you're somebody who is receiving SSI or you have a family member who's receiving SSI, it's important to note that the balance of an ABLE account, if it exceeds $100,000, could actually be counted for SSI purposes, at least until that balance drops back below 100,000. For Medicaid purposes, though, the account balance shouldn't impact your eligibility or ability to receive benefits. So that's just something to take note of. Now, when you open an ABLE account, the expenditures, similar to a first-party special needs trust, are subject to certain restrictions. And so the money that's in an ABLE account, there's tax benefits to putting money in an ABLE account, but the money that's in an ABLE account can only be used for certain qualified disability expenses. And those would be expenses that are incurred at the time that somebody was considered eligible, or maybe their expenses related to that disability, or their expenses that help the disabled individual to maintain or improve their health, maybe helps them maintain their independence, or just general quality of life expenditures. The expenditures out of that account can actually be subject to audit by the IRS or the Social Security Administration. So they will get a report and can then question the expenditures that are being made. And so you want to make sure that you are spending it on things like housing, maybe preventative care, education, transport, adaptive equipment, there's job training, basic living expenses, things like that. If you're not using those funds properly, you can actually be hit with a little bit of a tax consequence. There's a penalty, and the expenditures could be counted against an applicant or somebody who's currently receiving those means-based benefits. So it's important to make sure that you're spending those funds correctly. There's contribution limits. So the other thing with the ABLE account is you want to make sure you're not contributing too much to that account in any given year. The contribution, $15,000, so it mirrors the gift tax exclusion, your annual gift tax exclusion. But contributions like this third-party special needs trust, contributions can be made by family members or other third parties for the benefit of that disabled individual. The other distinction is there is a Medicaid payback requirement with an ABLE account, but it operates a little bit differently than you'll see under the special needs trust. So if at the time you pass away with an ABLE account, you have certain outstanding qualified disability expenses, those can be paid along with funeral and burial costs from the ABLE account before the remaining amount is subject to that Medicaid or state recovery provision. Doesn't work like that with the special needs trust. So that's definitely something to take note of.
That's an important note, because with a self-settled special needs trust, you can purchase a prepaid funeral as long as you purchase it before you've passed. You can't then pay funeral expenses after the person has passed away. All of it's subject to a state recovery. Mm-hmm. So there's a ton of information out there. It sounds like there's a lot of different planning options available. Certainly the clients don't need all of these. So I think it's important to let the clients know, exactly what their options are, so then we can then tailor that estate plan to best suit their needs moving forward. And certainly, all this can be changed. But all right, so before I ask my last question, where can everybody find you in case they have any questions?
Sure. So as you mentioned, I'm an attorney with Bratton Estate and Elder Care Attorneys. You can find me if you go to our website. You can find my contact information on there, but you can reach out to me at Bravette, it's B as in boy, R-A, V as in Victor, E-T-T-E, at BrattonLawGroup.com. It's B-R-A-T-T-O-N, Law Group. Or you can just give us a call at 856-857-6007.
I feel like we can keep going talking about this. It's very complicated, but it's interesting at the same time. I don't think there's a lot of information out there for people to really grasp all of this and understand that they don't have to disinherit their family member. There's a lot of different options out there to make sure that disabled individual has a better quality of life. So it's important to plan, but before we go, give everybody what you feel is a key takeaway with regard to special needs planning and any advice that you may be able to give individuals that are listening.
I would say if there's one thing to really take away, it's as you said, there's not a lot of information out there, or the information that's out there is maybe not the most accessible to the average person who doesn't deal with this all day long. And I mentioned that some of these types of trusts are irrevocable, and the guardianship that requires court intervention. So we're dealing with complex matters, and I think it's important to figure out. So sometimes the more complex and higher cost approaches to estate planning are marketed specifically to special needs families, but there is no real one size fits all approach to this. And so I think it's especially important within the special needs community to realize that, and also realize that all of these complex devices, the special needs trust, the different types, the guardianships, the ABLE account, those things might not be necessary. Just because you have a diagnosis or some type of developmental disability or physical disability, whatever it may be, doesn't mean that you lack the capacity necessary to execute more standard or more typical estate planning documents like a will or a power of attorney or an advanced care directive, things that would accomplish very similar results and be a less time and resource intensive and a more cost effective strategy for many families. And so I think it's important to do your homework before you go in to meet with any attorney from any firm, but especially within the special needs arena, and make sure you're working with a law firm or an attorney who's knowledgeable and experienced in the subject area and you really feel comfortable with.
Yeah, all good points. Listen, I appreciate you coming on and informing the audience, educating the audience about this. It's definitely a complex field. Thank you to everybody who listened today. If you have any questions for us, feel free to reach out and visit our website, brattonlawgroup.com. We will be here every Tuesday, providing you with more information, any free content, as much as we can provide to you. And thank you. Thanks again, Matt. Everybody have a great day.
Thanks for having me.